Just when I thought California's magazine ban was on its last leg, the Ninth Circuit stepped in and brought it roaring back to life. This ruling's not just a legal win for the state. It's a warning shot for gun owners across the country. What's up, everyone? This is Ted from Line 45, and today, let's get into how California's ban on 10-plus round magazines just got revived by the Ninth Circuit and how it can impact us, or those who are running standard capacity mags in your AR, Glock, or carry rig. Before I start, I would really appreciate it if you would push those buttons below. The subscribe button, the notification bell, all of them. This is not necessary, but those little clicks help a brother out. Plus, it pushes me to give you more valuable gun-related content on your screen. Now, buckle up, and let's get back to the video. I'll be real with you. I figured this law was done. Back in 2020, we saw Judge Roger Benitez strike down California's magazine ban as unconstitutional in Duncan v. Becerra, calling it a direct infringement on the Second Amendment. A lot of folks across the state jumped on that moment. That's when we got Freedom Week, where thousands legally bought and imported standard capacity mags. Glocks with 17-second, Arkansas S with 30-second. It was all fair game for that brief window. Then the Ninth Circuit blocked it again, pending appeal. Fast forward to March 2025, and now we've got the full en banc Ninth Circuit, 7-4, siding with the state. The court says California's ban on magazines over 10 rounds is not only lawful, but doesn't violate Bruin or Heller. That hit hard. This isn't some lower court skirmish. This is a full-blown federal ruling with major implications. They're saying either magazines aren't arms at all, or even if they are, the state can still ban them under the historical tradition test from Bruin. This move resets the whole field for California gun owners. If you've got mags you picked up during Freedom Week, the law just got a whole lot murkier. We're going to walk through that too. But before we go there, we've got to understand what this law actually bans and why it affects more shooters than most people realize. Let me lay it out plain. California Penal Code Section 32310 bans the possession, sale, transfer, manufacture, importation, or even gifting of any magazine that holds more than 10 rounds of ammunition. It doesn't matter if it's pinned, blocked, or OEM. It doesn't matter if it came with your Glock 17, your SIG 226, or your AR-15 straight from the factory. 10 rounds is the ceiling, and it's been that way, at least on paper, since the year 2000. Now, the reason this hits so hard is because the kinds of magazines this law bans aren't fringe gear. They're the standard. Most pistols on the market today ship with mags holding 12, 15, or 17 rounds. Most ARs run with a 30-round mag straight out of the box. These aren't high capacity in the real world. They're just what comes with the gun. But California rebranded them to push this legislation decades ago, and now the courts have handed them a stamp of approval to enforce it again. This ruling doesn't carve out exceptions for older mags or pre-ban gear. It doesn't say Freedom Week purchases are protected. It's a full reset. And if you've got a 15-round mag sitting in your nightstand or in a range bag, you're back on uncertain ground. Up next, we'll dig into how the court justified keeping this law alive, even under the Bruin ruling that was supposed to tighten the leash on gun restrictions. And that legal framework is where this whole thing takes a turn. If you know New York State Rifle and Pistol Association versus Bruin, you know it changed the game. It told every court in the country that when evaluating a gun law, you don't get to weigh public safety or social concerns. You've got to show that the law is consistent with America's historical tradition of firearm regulation. Clean and simple. Or at least, it should be. But the Ninth Circuit's majority saw some daylight. In their March 2025 opinion in Duncan v. Bonta, they argued that large-capacity magazines aren't even protected arms under the Second Amendment. They called them accessories and claimed they're not necessary for lawful self-defense. Even if they were arms, the court said, the ban still fits within historical patterns of restricting especially dangerous or unusually lethal weapons and accessories, pointing to things like 19th century laws limiting concealed carry or banning trap guns. They leaned hard on that dangerous and unusual carve-out. The majority basically said that since 10-round magazines are more than enough for home defense, the state has room to regulate anything beyond that. That logic left a lot of us shaking our heads. These aren't exotic mags. They're the same ones issued to law enforcement and used by civilians in free states every day. Now, not everyone on the bench agreed. One judge went way beyond a written dissent and did something I've never seen in federal court. This wasn't your standard written dissent. Judge Lawrence Van Dyke, one of the most vocal Second Amendment voices on the Ninth Circuit, didn't just disagree with the majority. He made sure the public felt it. Instead of filing a traditional written opinion, Van Dyke released a video dissent on YouTube. In it, he personally handled and demonstrated multiple firearms and magazines to argue why 10-round limits are arbitrary, unsafe, and outright unconstitutional. Now, I've been around guns my whole life. Watching a federal judge rack an AR, load standard capacity mags, and calmly explain how limiting a shooter to 10 rounds can increase danger in a real self-defense scenario, especially against multiple attackers, that hits differently. He wasn't doing theatrics. He was showing real-life mechanics that any shooter understands, but too many judges ignore. Of course, the legal elite lost their minds. Some peers called it unprofessional, reckless, even a breach of decorum. But for many of us, it was the most honest courtroom moment we've seen in years. Van Dyke made the case like a shooter would not a detached bureaucrat. And whether you agree with his method or not, the message landed. This isn't a theoretical argument. It's a debate about real gear that Americans use, train with, and depend on. So what happens now if you're a California gun owner holding mags you legally bought? Well, if you're holding on to magazines you bought during Freedom Week back in March 2019, you're back in legal limbo. When Judge Benitez originally ruled the ban unconstitutional, there was a 1-week window where folks legally bought millions of standard capacity magazines. Everything from Glock 17 mags to Magpul P mags moved fast. Some shops were selling out within hours. Back then, it was the law of the land. You could buy, sell, and use 30 rounders without breaking a sweat. But now that the Ninth Circuit's en banc panel has reversed Benitez's ruling, California can once again enforce its full ban under California Penal Code Section 32310. That includes not just buying or importing new mags, but possessing them. And that's the part a lot of folks don't fully grasp yet, and that is possession is the trigger. This means that even if you bought them legally during that window, you could now be charged for simply having them in your safe. The state hasn't rushed enforcement yet, likely because they know this ruling could head to the Supreme Court. But it's back on the books. No exemptions, no carve-outs. And unless you're law enforcement, you're expected to destroy, sell out of state, or surrender any mags over 10 rounds. People keep asking me, should I get rid of mine now? Legally, that's between you and your lawyer. But practically, this fight's not over. And other states are already watching California to see what happens next. Now here's where things get serious for folks outside the Golden State. California isn't the only place with a magazine limit on the books. New York, New Jersey, Connecticut, Maryland, Massachusetts, Hawaii, and a handful of others have their own 10-round caps. And with this ruling from the Ninth Circuit, those states just got legal cover to double down and defend their bans, using the same arguments California did. That's the big takeaway here. The court didn't just rule on California's law, it laid out a blueprint. The majority leaned hard on the idea that magazines with over 10 rounds are not necessary for lawful self-defense and are subject to restriction based on historical analogs. Whether you buy that or not, that's the new playbook anti-gun states are now holding in their hands. It also deepens the circuit split that's developing across the country. Courts in the Fifth Circuit and the 11th Circuit have taken the opposite stance, striking down similar bans or signaling that standard capacity mags are protected under Heller and Bruin. That contradiction sets up a direct path to the Supreme Court. And if SCOTUS takes it, they'll be forced to draw a line. Either these mags are protected arms or they're not. Until then, don't be surprised if states like Illinois or Washington try to pass new bans using California's legal win as cover. This is the kind of ruling that spreads. And that leads me into my final point. Here's the million-dollar question every gun owner's asking. Will the Supreme Court take this case? After this Ninth Circuit ruling in Duncan versus Bonta, we've now got a full-blown circuit split. Some courts say magazine bans violate the Second Amendment. Others, like the Ninth, say they're constitutional under Bruin. And when federal circuits are in conflict, it puts pressure on SCOTUS to step in and unify the standard. Word is, the lawyers behind Duncan are prepping a petition for certiorari. They'll argue that the Ninth Circuit misapplied Bruin and ignored common use. After all, tens of millions of Americans own magazines with over 10 rounds, and most new firearms ship with them by default. That's going to hit hard with justices like Thomas and Alito, who've already said time and again that common use matters. But let's not get ahead of ourselves. The court doesn't take every case, and it may want to see more lower courts weigh in. In the meantime, California can enforce its law, and states across the country may follow suit while SCOTUS holds back. So here's what I'd say if you're watching this as a gun owner. Stay sharp, keep your gear legal, know your state's rules, and keep your eyes on the Supreme Court docket. Because when this finally hits the High Court, the answer they give will shape gun rights in America for decades to come.